Hello there, guys, and yeah, thank you all for coming down today to this kind of little bit of a one-off special webinar, which we've kind of just thrown in because we've had a lot of questions, a lot of clients coming to us with not running scared, Paul, but a little bit of concern about what's
Yeah,
happening with Royal Assent and Renters' Rights Bill, really. So we thought we'd jump on. I'll borrow Paul for half an hour or so, and we just go through what actually has changed as of the 27th of October, when the bill has obviously got royal assent. So, first of all, I suppose for those that don't know us and are watching this, maybe all around the country, we're a local family-run firm in Essex, Suffolk area, Boydens Limited. My granddad set up the firm in 1966. Dad's been in the firm for 40 odd years, taken up chairman role, and now I'm in the managing director seat. Still very much family run, but also certainly moving with the times, keeping everyone updated on topics like this today. But yeah, we do everything from letting, sales, block management, as well as property sourcing and the investments nowadays. So that's a little bit about that this is about today. So without further ado, Paul,
Mm.
what does getting royal assent really mean? What does that mean?
So it basically means the bill is now an act. So essentially, it's a law. Um, what happens now is there are stages of implementation that we're waiting for the guidance basically. But just to give you an example, just I know that a lot of people have been contacting us, and because obviously they hear that it's been given royal assent, it's now law. I think
Yeah.
there's this general confusion that, okay, so does that mean I can't serve section 21? Has it all changed with immediate effect? Well, no, it hasn't. So as of here and today, nothing has changed. Okay. Yes, it received royal assent on the 27th of October. The next date of implementation is the 27th of December. Now, it doesn't really, it's not really much for the landlord and agent to do on that. That's more to do with the local authority and the powers that they have. They need to report to the Secretary of State on how they're going to enforce the law. Um, One thing it does do, it does give them the power as of that date to investigate any potential breaches in the future. So they can start collating information, and they can use various sources such as council tax, deposit registrations, any benefits information in order to prepare potential cases. So that's quite interesting that they have the power to investigate now before it becomes a sort of a live piece of legislation for landlords and agents, which we suspect will be in April next year. So
Mhm.
that's one of the key things, and I think we've covered this very briefly on previous webinars in terms of how the local authorities are going to enforce this. And one of the key things is, and quite scary, is ability to access records, i.e. walking into a letting agent's or a landlord's place of employment and accessing the records without a warrant and taking away data to investigate. It seems quite extreme. But as I say, from a landlord's and an agent's perspective, it's business as normal.
Mhm.
Obviously, we need to be aware of it. The biggest date for us, and again, this is only estimated because the dates haven't been released by the government as of yet, but we believe April next year will be the date.
Where's that kind of date come from? Because I know that's been spoken about very
Yeah,
openly. Is that just
well,
6 months?
the industry's been asking for
Time?
6 months implementation date.
Right.
That's really so. The industry is kind of looking at this and going, right, this is a lot of work that needs to take place for landlords and agents. There's a lot of information. Bearing in mind, this is the biggest shake-up in lettings for 40 odd years. This isn't something you can bring in overnight and expect everyone to be compliant. Also, there's a lot of complexity to the legislation that landlords and agents need to know. I'm not going to mention various politicians who have fallen foul of existing legislation, but it does go to show the length and breadth of how complex housing legislation can be. So there's this. We've asked for 6 months, and we're working on the assumption that yes, we're going to get this 6 months, which would mean it will be in April next year. that's when we will lose the ability to serve Section 21. That's when every tenancy agreement will becomes a assured periodic from day one, no more fixed terms. The new grounds for possession will kick in then. So the 25 mandatory and the 11 discretionary um, possessions. There'll be limits on rent, no rent in advance. Again, we can cover that later. Rent increases via Section 13 with evidence. That is going to be the only form for a landlord to increase the rent. No more rent reviews as mid-tenancy as part of the tenancy agreement. And then the last one will be the ability for tenants to request.
Mhm. So, Paul, in terms of, obviously, for a little bit of background for our own clients or managed clients, we are going to be doing a private client webinar as well for our own for our own landlords, so that will kind of give you some rest assurance as to what we are doing as a company to protect your kind of investment. So we're looking at probably doing that at the start of December. So please do keep an eye out for that if you are one of our managed clients, and we'd look forward to seeing you on the evening when we do go through that in a lot more detail. But I suppose we've had a couple of hot questions or hot topics, which I'm just going to run through. I know that you've said
Okay.
nothing has changed, but there's still going to be a little bit of nagging kind of doubt, I'm
Yeah.
sure,
Oh, 100%.
for some landlords out there. But so at the moment, how do I get possession for my property if I want possession back as of now?
So So possession, we can still secure possession in the way that we have done so. It could be via a Section 21 notice
Yeah.
or via a Section 8 under the 17 different grounds that are available under Schedule 2 of the Housing Act. I would say that under Section 21, under the accelerated possession proceedings, so assume you issue a notice and the tenant doesn't leave, you can claim under accelerated possession proceedings. We are seeing a lot of kickback from county court
Yeah.
in terms of the level of information they are requiring. So, to give you an example, I'm arguing one today where they have requested notice of service for the last 10 years worth of gas safety certificates, irrespective of whether the fact that the gas installation use regulations only require a landlord and agent to retain the last 2 years worth of gas safeties.
Yeah.
But they won't, the county court won't accept the claim unless we can provide them
Yeah.
with that information. So
It is again about a landlord. If you are self-managing or etc., you make sure you've got all your paperwork kind of squeaky clean
yeah,
before you are serving that notice. There were annual things in our previous webinars. Again, go back and watch those about making sure that you're doing these annual things every year, because otherwise, the Section 21 will be thrown back a lot quicker than maybe it would have done in the past. Paul, would that be fair in saying them?
100%. It feels like there's a remit from government to county court to try and stall as many Section 21 possession claims as possible, because invariably what's going to happen is now this is happening. We've already seen a massive influx of Section 21 notices wanting to be served because landlords are wanting to protect their position, or maybe they took a punt on a tenant, gave them the benefit of the doubt on the basis they could issue a Section 21 if that tenancy went bad. Obviously, that ability to do that will now go once this is active. And those landlords can't afford to or don't want to have that risk, understandably. So they'll look to remove that tenant and get someone else in who gives them that security.
So to clarify, as of today, you
Yep.
can still serve a Section 21, but
Yep.
just make sure you're still, or you're squeaky clean. You've got everything you should have done
Correct.
up to date. And do you think is there going to be, as of say a hard and fast date as of April, if that does come in, does that still mean that we're able to seek possession after that date if the Section 21 had been served before that date, or is that still a little bit unknown?
It's okay. So there's the actual wording hasn't come out yet, but there was discussions to say that there is going to be a period of time after the act is live with us that you can enforce a previous Section 21. So the idea being, so let's assume it becomes active on the 1st of April for landlords to letting agents. Then if you have a Section 21 that's already been served, you may be able to still progress that through to possession. However, they will give you a timeline. I think it to be 3 months. After that, then that's it. But again, we don't know.
Yeah, yeah.
The wording hasn't yet been released.
But we will certainly keep you guys updated as soon as we know. Then we'll do something probably similar to this. Hopefully in a more of a formal setting. We're hoping actually to in-person seminar, perhaps when it does actually get implemented, so to speak. But a hot topic that is a strange hot topic, really. I think it's maybe pets in let. So do I have to give permission for that Great Dane in my one-bedroom flat? Do I have to allow permission for
So
that?
this was interesting because you remember when this first came out, it was like landlords have to give, they can't unreasonably withhold permission, but then there was no guidance to unreasonableness. It was just, it was left to discretion. Then there was talk of mandatory pet insurance that the landlord could take out. That was boo-boo. Then there was talk of additional deposits that would have to be paid in the event of a landlord giving permission for pets. So that was boo-boo. So now nothing has changed. It's still the 5 weeks deposit, but there's no protection for the landlord. The landlord does have the right to decline. They get given 28 days from the date of request to make a decision. They can't just say no. There needs to be a reasonable excuse, and one of those excuses could be you could look at the Animal Welfare Act, 2006, I believe, which could protect the landlord. So in the event that somebody did want a Great Dane in a flat, you could argue, well, that's not fair on the animal. The other one is any head leases that don't allow provision of pets within properties. Obviously, that can be included. It'll be interesting to see how this pans out and whether what's considered a reasonable excuse and what isn't. It's more guidance is needed. I suspect we don't get any more guidance, however, and it's going to take a few claims before it's eventually ironed out as to what a reasonable excuse is. But as it stands at the moment, a tenant can request, well, as of April next year, a tenant can request a pet and the landlord can't say no.
Right.
Without a reasonable excuse.
Reasonable. I think there's going to be a lot of using your noggin in terms of actually, what if you've got, if you say a Great Dane in a flat or a crocodile in a house, you're not going to be. It's not
crocodiles, yeah.
But so that's fine. But up until now, you can still say no.
Absolutely. And you can still advertise no pets. Nothing changes at the moment. As I say, it's estimated this is going to be April. But as you said, as the time ticks by, more and more information is coming out, and we'll put together a whole pack just to let people know what's what.
And also, I think it is important to say, because there is a lot of obviously the Section 21 notices are ending, but you can still kind of serve notice for other reasons. So if you do want to sell the property, you can still serve notice. There are reasons then you can't re-let it for a period of time if the sale wasn't to go through. But there are still grounds there for people to use to gain possession back. It's not like it's a secure tenancy like it used to be back in the day, where you couldn't get anyone out for any reason whatsoever. There are still grounds there that landlords can call upon for,
I think,
for their own use, really. Go on, Paul.
yeah,
Yeah.
add some context to that. They have beefed up the
Yeah.
possession grounds, because there used to be 8 mandatory grounds. There are now 25.
Yeah.
So that just gives you some idea of the amount of grounds that are there. So it used to be blanket section 21. If you wanted possession, as long as the tenant wasn't in arrears, it's section 21, job done, that's me getting possession.
Mm.
In the absence of section 21, you just need to look at the grounds. So you're absolutely right. If a landlord wanted to sell, there is a notice for that with a 4-month notice period. If the landlord wanted to move back in, there's a notice for that with a notice period, etc., etc. And then obviously there's still the tenancy breach ones where the notice period is less because it's a tenant breach.
Yeah. Whilst we're on that, actually, no, we won't go down a rabbit hole of all of those, because we'll be on here for the next
We will be on here for a
hour.
long time.
So we'll save that for one of our longer webinars. But currently, what happens if my tenant falls into arrears as of now until April?
As of now, so standards. Well, it's if you're a managed client, you don't worry, because more often than not, you've got a rent guarantee. And what we would do is we make a claim under the rent guarantee, so it won't actually affect you as a landlord, other than ultimately we're getting possession for rent arrears. But let's assume you don't have a rent guarantee and you're self-managing property, you can still take action as you would now. So when the account reaches 2 months rent arrears, you go down the route of Section 8, grounds 8, 10, 11. In order to get possession of the property via the county courts.
So
Business as normal. Yeah. Yeah.
normal.
Again, that will not change until the next implementation date, which we estimate to be April.
Mm-hmm. And even then, it will be fairly similar, but it's the length of time that they are in arrears gets extended. So it just makes
goes from 2 to 3 months.
Yeah.
So and the notice periods increase. Yeah.
Mm-hmm. I think just talk about just because of the fixed term tenancy, there was quite a bit of chat amongst people thinking, that there isn't going to be a 12-month fixed term. So there's a lot of people were confused or were maybe a little bit nervous that suddenly, a tenant would move in and then they'd move out within a month. I think on a realistic basis, even if someone wants to do that, which Paul will explain how long it would actually take them in a second. Say if there was legislation that they could do that, there's so lack of property out there. The demand is high. For a tenant to find a new property at the moment is an absolute nightmare. So they're not going to go through that every couple of months, and you're not going to have loads and loads of changes of tenancies over a 12-month period, in my opinion. I can't see that coming in. Can you, Paul? I just unless suddenly there's masses of stock, I can't see it.
No, I mean it's the law will allow for that. So the tenants have to serve a minimum period. Whilst there's no fixed term, they need to serve minimum 2 months notice, but it has to be from the rent due date, which is the key thing as well. But you're absolutely right. We have something between 15 and 20 applicants per property that goes on the market. So it's we all know there's a distinct lack of available lettings stock on the market. That doesn't look like it's going to improve anytime soon. Tenants are desperate for properties. So no, there's actually no rhyme or reason why a tenant's going to move in, go through all the cost of moving in, and then shortly thereafter move out, unless there was a catastrophic problem at the property that wasn't being remedied by the landlord.
Yeah. And as you say, a rent due date. So if someone moved in today, served their notice tomorrow, then it would actually be 3 months from then, basically, isn't it?
Yeah, the notice would go from the next rent due date. Yeah.
So that's there in there. But any other kind of key points to bring to landlords' attentions at the moment, Paul? It's just
One thing we didn't say is obviously 27th of December, it was predominantly local authority involved, but there is something in there that does apply to landlords and letting agents, and that is not to discriminate against applicants with children or in receipt of benefits. So we've all seen it, that there's blanket advertising on property saying, sorry, no children, sorry, no one in receipt of local authority. That will be considered discrimination, and that's no longer permitted. So what is not saying is that you have to let to somebody who has children, that you have to let to somebody who is in receipt of benefit. They should be given the opportunity to apply. And in the past, what's happened is landlords may have been restricted by mortgages who don't allow, or particular insurance policies that don't allow those in receipt of benefits to rent the property. That will be null and void going forward. This law will supersede that, and landlords will have to, if that particular person wishes to apply, they have to accept the application, allow the viewing to take place. Ultimately, at the end of the day, it doesn't mean you have to accept them. This is a financial application, so they need to be able to prove that they are financially viable to let the property and have those finances in place. But you can't just blanket say no, you can't
Okay.
apply.
Okay. Super.
Yeah, I mean, other than that, there's the Arabs law. We talked a lot about Arabs law. That's active in the social housing.
Yeah.
That will come under this act in to private residential lettings. It's expected that that will be October 2026. That will be here before you know it. So that's something that everybody should be gearing up for next year. The ombudsman, the landlord ombudsman, will probably follow the following year, so possibly 2027. And
Really?
then,
Crikey.
yeah,
Okay.
well, it's this. The government wants to use their own ombudsman. They don't want to use an existing ombudsman's, even though they're set up. They don't want that. So that's a lot of work
Yeah.
to set up. As I say, these days are all estimated. And then finally, it's the decent home scheme, which could take up to 9 to 10 years before it gets here,
2035, wasn't it? I think they were
potentially.
saying.
Yeah. Again, there's a lot of work. I didn't think it was quite so much work, but there's a lot of work there. But
Yeah.
I hasten to add, there still is legislation in place, which is HHSRS,
Yeah.
fitness for homes for fitness, habitation, etc., etc. So there's already a lot there that we need to
Mhm.
comply with.
Super stuff. Well, thanks for your time this afternoon, Paul. I think that's hopefully just debunked a few myths and a few kind of scaremongering maybe that might be going around out there. It is very much stay as you are, act as normal, but certainly adapt and be ready for the change that is to come. As we always say, if you fail to plan, you plan to fail as such. So yeah, be aware of what's changed, and also on that note, please do join us, myself and Paul, on the 27th of November at 6 p.m., which is in about a month's time. Hopefully dust will have settled a little bit by then, and we'll be doing a bit more of a general overview as of what is changing on that front. We'll also be doing our usual kind of lettings and sales market update, and I believe we're also looking at some hot properties that are decent investments in this area. Some kind of, circa 8-9% yields and those kind of things. So there are great investments in our area as well. So anyone that is watching that is actually looking to grow their portfolio, we are selling properties where landlords are looking to sell. So ready-made investments. And also, the budget will have been announced when's?
I think that's 28th.
Oh, we've done that.
I think that's there's. I mean, one thing to also add on those off market, that's actually very current, because whilst the landlord can get possession to sell their property from a tenant, if it doesn't sell, they can't relet it for another 12 months. That's something to throw into the mix. So I think you'll find off market sales being far more popular for landlords, because the potential there is to lose a year's worth of revenue.
Yeah.
They tried to get it down to 6 months, but they couldn't. So and the other thing as well is on the webinar, live Q&A. That's always very, very good.
Yeah.
Yeah.
Yeah. Really good. So guys, if you have enjoyed that, please do jump on Google. I'll put a link at the bottom of this video on YouTube. It'd be amazing if you can give us kind of a Google kind of rating on there. If you have enjoyed and taken something out today, that would be absolutely amazing. But yeah, hopefully see some of you guys on the 27th of November. And any questions, queries you've got at the moment, feel free to get in touch. We'd love to hear from you. And yeah, we'll wish you all well and speak to you soon. Cheers. Bye.